other things involved as well. Not all that dissimilar to like when someone is talking about using Medicaid for a skilled nursing facility, where there's certain amounts of things they have to be aware of with like how much you can have in terms of assets, and did you give anything away to the kids, things like that. That is, there's some overlap there for this program. So we'll be talking a lot through that. But if there's anything that anybody has any questions on about, that topic, or just general sort of estate planning questions too, if there's nothing specific on that, then there is the ability for people to add that through the Q&A function. So there's a lot that we're able to see as those questions come in. You'll be getting a couple of resources as well. One is sort of a flyer on the VA benefits that we're going to be talking about, and what that actually looks like in terms of how that pension program works. And what the current ranges of those pensions are. They change every year. They go up with inflation, so they're not always going to be the same. And actually, they're subject to change pretty soon here in the next couple months, right? So we're getting close to the end of 2021 now. So that'll change, and then some of the asset qualifications will change as well. So with that, the other thing I'll talk about too is, we are going to send out some things for the, like a feedback form, blanking on the word. Oh, and I did see that we just went live. So for everything I just said, I'll repeat for you guys, but I'm attorney Justin Randall with Hooper Law Office. Our topic today, again, is on the improved pension program for VA benefits, or sometimes it's referred to as aid and attendance. It's part of that same sort of subset of benefits. And I'll walk you through what that program looks like, what the qualification requirements are, and give you an idea of what that looks like and how it can be helpful to you as a veteran or a surviving spouse of a veteran. And a couple of materials you'll get from us are the flyer on those benefits, and it'll give you a breakdown of what the pension amounts are for 2021 anyway. Next year, that's subject to change, obviously, as with inflation, it gets adjusted every year. The other thing you'll receive from us is a feedback form, which gives you a place to mark down that you'd like us to reach out to you if you want to set up a time to come in and talk to one of the attorneys in our office about anything we've discussed. Those initial consultations we offer are complimentary. They don't, nobody's paying us to come in for that initial consultation. We usually schedule them for around 2 hours. So give us enough time to talk through some of the issues that somebody might be coming in with. And then coming up next week, actually, is our in-person public seminar here at the Bordini Center in Appleton at the Fox Valley Tech. And that will there's 2 sessions for that. It'll be at 2 and 6. Those are, again, scheduled for about 2 hours. They don't always take that long, depending on the number of questions and people that are there, all of that. If you want to sign up in advance, that would be ideal. I believe they're still limiting capacity, so it'd be good to get in while you can. If you want to sign up for that at estateplanninglive.com, the sooner you sign up for that, because there are limited spaces available, or limited seats, I should say, due to capacity requirements right now. The sooner you do that, the better. But there are the two sessions as well. So you'll be able to do either a 2 p.m. or a 6 p.m., whatever's more convenient for you. And then we're off the week after that for Thanksgiving. So to get started on some of this, and I forgot to mention, there is a Q&A function. So if you have questions during this, you can submit them and I'll see them. So I'll try to answer those as they come in. So the program we're talking about today is known as the Improved Pension Program through the VA. It is a benefit for wartime veterans or the surviving spouses of wartime veterans. That is one of the main requirements for this program is the service requirements. There's sort of 3 main requirements that somebody has to meet in order to qualify for this benefit. One is the service requirements, and I'll go through the specifics on that in a second. The next are asset requirements. You have to be below a certain point. Sort of like if you've ever talked to somebody planning for long-term care with Medicaid, right? There's asset requirements for that too. The third is an income requirement. So this benefit is a pension benefit and is very heavily tied to what the VA looks at as that veteran or their surviving spouse's income. So if you're over a certain amount of income, you also don't receive this benefit either. But the service requirements are probably the most specific in terms of what somebody has to have in terms of their service to qualify for this. The VA, the first is, I should say, that they're a wartime veteran. So that means that they served during a set period of time that the VA has defined as a wartime veteran. So, I mean, the big three obviously are, World War II, Vietnam, or I should say in order, World War II, Korea, and then Vietnam. But it can apply to anybody post 1980 as well. The rules are just a little different for those veterans. So the dates for these wartime periods, though, are not always what you would expect. They're not the same as what you might see in a history book. World War II, for example, according to the VA, actually ended on December 31st of 1946. So it's a year after the history books might tell you, or a little over a year after, actually, of what the history books might tell you of, instead of like August of 1945, excuse me. So that is something to be aware of, and not think that you're suddenly not qualified as a wartime veteran just because you're after what a history book would tell you is the end date to that conflict, right? So it's important to know what those dates are, and those are available, actually, if you search them through the VA, those are always available for you to look up. The other qualification for the service is that you had to have served active duty. So you couldn't have been in the reserves, for example, or, a lot of times the National Guard does not qualify for this if they were not an activated member of the National Guard, if they're just here at home, or, in some cases, other types of, for a long time, for example, the Merchant Marines didn't qualify either. And that changed a few years back, I believe. So it's just important to know that you're service qualified. I mean, if you're part of the kind of the main branches of the military, it's pretty clear that you do qualify if you served during that wartime period and you were active duty. The length of time you had to have served was at least 90 days of active duty, which means it couldn't have been for like training purposes, right? Or it couldn't have been while you were in the reserves for those 90 days. You had to be active duty for 90 days. Only one of those 90 days actually has to have been during the wartime period, though. So I always use this as an example. Somebody could have started on, December 30th, for example, of 1946, and the rest of their 90 days, or I guess at that point, 88 days of service after the 2 days of active duty during the wartime period. As long as they were active duty for a full 90 days, if the first couple of days were during that wartime period, they're still a World War II veteran, right? So it's not that all of the 90 days had to have been during the wartime period. It could have been any number of those 90 days, as long as it was 90 days total of active duty. It could have been the end of it too, right? It doesn't matter where that falls. The other thing is they could not have been dishonorably discharged. So if there was a reason that they were removed from the military, right? If it was a dishonorable discharge, that does not qualify you for active duty service either under this definition. And it does not matter if this person was actually boots on the ground over in a theater of combat. They could have been here in the US the entire time, as long as they were active duty. So that's the service requirement. And that, again, is the veteran who served. It does not have to, their spouse does not have to have served in the same period of time or at all. Then, just like Medicaid, there are some asset qualifications that, you can't have more than a certain amount in order to qualify for this benefit. So if you're familiar with Medicaid, I mean, you might be sort of familiar with how these where these numbers are coming from. But the VA says that the veteran and their spouse, they don't distinguish, between a married couple or I should say they have no distinction between a married couple and a single person. It's the same regardless of whether that veteran is married or not. They can have a home and up to 2 acres of land surrounding that home, and it is not counted towards the total amount of assets they're allowed to have. So it's basically as if it has no value for qualification purposes because they don't count it against you. If you have more than 2 acres of land, they can count the value of that land towards your total that you're allowed to have, unless the local laws, your zoning laws say you can't sell a lot below a certain number of acres. So a lot of times out in, the countryside, for example, lots have to be a lot larger than they would be in the city. So if your local law says you can't sell a lot below 10 acres of land, well, then for the VA, if you have a home and 10 acres of land in that local area, that would also be exempt. And that's because they can't force you below what you can actually sell in terms of your local laws. It's one of the few programs we deal with that is very reliant in that sense on local zoning laws. It doesn't come up a lot for like Medicaid, for example. So after that, though, all of the other assets of the veteran, so bank accounts, retirement accounts, cash value of life insurance, potentially vehicles over a certain amount, other pieces of real estate, right? The rest of those count as assets. They look at the total value of everything, whether it's just in the veteran's name or in the spouse's name or in both their names, that doesn't matter. It's just everything else qualifies as an available asset. What that means is that, they count it up, they add up the total of what it's worth, and they say that veteran has to be below of available assets, roughly $130,000. So if you're over that, you just don't qualify. And again, that's not including the home in that 2-acre rule. So that would be taken out. I mean, somebody could have like a $500,000 home and then $50,000 in assets. And in theory, that could potentially qualify, right? So it's just the other assets, sort of the cash assets, the investments or retirement funds, those are countable. So this program can be a little more, harder to qualify than somebody might expect, because it's not just tied to service in terms of, okay, you serve, so you get a pension. This is specifically designed for veterans who are below a certain amount in assets to help them supplement income. So the income requirement for this, as I mentioned, there is an income requirement as well. It's not so much that you have to be below, there's no set be below this amount, but what they look at is they look at the max benefit that veteran can receive, the max pension they're allowed to receive through this program, and they subtract from that benefit whatever income the veteran is receiving. So if the max benefit, to give you an idea, roughly for like a single veteran, wartime veteran, is roughly around, I believe, like $2,200 right now, if I'm remembering correctly. The exact dollar amount's escaping me, but it's roughly about $2,200 a month is what that veteran could receive through this program. And that's a single veteran, I should say. But if you look at what their income is, then if they're getting $3,000 a month, either through Social Security and maybe a work pension, they subtract that from that 22, which you can't go below zero. They don't force you to pay in, but if it goes down to zero, they say you don't get anything, right? You don't get this benefit because you have too much income coming in. So it's not available without the need of care anyway for a lot of veterans, unless they're relatively low income. If that's the case, though, it can be very helpful for them. But where we tend to deal with this program quite a bit is when we're looking at a veteran who might be in need of care soon. And the reason care is really heavily tied into, at least our approach to it, is because for the VA, when they do that income calculation, what they call the income for VA purposes, the IVAP, they, from that veteran's income or their income and their spouse's income, they subtract unreimbursed medical expenses. So when you're paying for care at a facility, or if you just have chronic care needs for some reason, whether it's long-term care or not, that can be removed for calculation purposes from that person's income. So to give you an idea or a more specific example of what I'm talking about here, let's say that somebody is getting roughly $4,000 a month in income without the VA involved at all. But then they go into a facility and their care needs or the cost of care at that facility is $6,000 a month. Well, this is more than their income. So that's an unreimbursed medical expense to that payment to that facility, the long-term care facility. So they subtract that from that person's income, and it looks to the VA then like they have no income, which means they could get the max benefit from the VA. And I use that dollar amount specifically to show that that could be really used to bridge the gap, because if the max benefit is around $2,200 a month, that $2,000 shortfall that they had for their cost of care between their care cost and their income could potentially be made up by that improved pension program. So it's a direct pension payment directly to the veteran or the surviving spouse of the veteran. And it goes to their bank account. So it can be used to supplement these types of expenses. That's the really common use for it these days. But I've also heard examples of people using it just for low income veterans too. As I mentioned, it can also be used for surviving spouses of wartime veterans. They don't get quite as much of a max benefit. It's closer to around $1,300 a month. But it's a little lower than the veteran themselves, but it's still useful for a lot of people, especially for a portion of the population where they're not as used to actually getting the benefits from it. A lot of times it's the surviving spouses of these veterans. They think they're not entitled to anything. And that's thankfully this benefit does exist for them. So, a lot of times though, what people talk about is, well, how do I have way more than that. How do I get down to that amount? Or, my retirement account alone is higher than that. Or, how do I get qualified for this? And how do I make use of this benefit? Well, it used to be prior to around, I think it was October 18th, actually, of 2018, if I'm remembering the exact day. Prior to that date, this program was often used. People would, transfer assets away, kind of like you might have heard people talk about Medicaid, for example, where they say, if you gift something away, you get a penalty for it, right? And with the VA, prior to this law or this rule change in 2018, people used to be able to get qualified very quickly for it because they had no look back period. They didn't care if you did it the night before, in theory, right? If you gave it away. That didn't matter for the VA back then, but they sort of changed their rules because that obviously wasn't working super well, and not for their sake anyway. And they changed it to a 3-year look back period. So you might have heard of the 5-year rule for Medicaid. That's the 5-year look back for Medicaid. How that works, how that look back period works for both the VA and Medicaid is that if in those timeframes, so 3 years for the VA, 5 years for Medicaid, if you transferred something away for less than fair market value, meaning you either gifted it to somebody or sometimes people ask, well, what happens if I sell my home for $1? That's technically a sale. Yeah, but you, in theory, sold it for way less than it's worth. So if you sell something for less than fair market value as well, the difference between the sale price and the cost ends up being a gift or a divestment according to the Medicaid and the VA as well. So, anything like that somebody did to get their assets down to those limits. So again, 130 for the VA. If they did that in the 3 years preceding their application for the VA, there's a penalty that's assessed based off of that. And it's assessed in terms of a certain period of months that they are not eligible for those benefits. So it's very important then for somebody to be very careful about what they're gifting away if it helps them get qualified. So Medicaid and the VA don't have the same exact definition of how this works. So Medicaid, for example, if you gave anything away for less than fair market value in the 5 years before your application for Medicaid to get help with the nursing home payment, they give you a penalty based off of the value of what you gave away. For the VA, the penalty is actually calculated based off of if it helped you get qualified for this benefit. So that is a pretty important distinction because Medicaid doesn't care whether it helps you get qualified or not. If you gave it away, you gave it away. The VA says if it was already within an asset, you were already financially qualified and you gave something away 3 years before your care, like as a Christmas gift or something like that, it doesn't count as a penalty. There is no divestment because you were already qualified. So in theory, for example, if somebody who had a home, let's say they're well within the 2 acres of land and about $100,000 of other assets, and they gave their kids a Christmas gift, let's say $100 each, just as an example, that wouldn't be a divestment for the VA because they were already financially qualified. So that kind of thing, it's important to be aware of those rules. What I would always recommend, though, is if you are looking to plan around those benefits, whether it's the VA or Medicaid, making sure that you talk with somebody who is an accredited VA attorney, or an attorney, excuse me, accredited with the VA. And that's really important because there's very specific rules around this. If somebody is not accredited with the VA, they in theory should not be giving that advice on that planning. And all of the attorneys in our office are accredited with the VA. So we're all VA accredited attorneys. We're all accredited to talk about these things. Essentially what that means is we have to keep up to date on the rules around that. We have to be able to, know what the rules on those programs are in order to even talk about it. And with the VA too, if somebody is already financially qualified, you can actually apply for this benefit through your local VSO's office. So nobody can charge you for the application of this benefit. So that's not talking about any legal planning somebody does around it. If it's not the actual application itself, if it's somebody doing estate planning, for example, in relation to their application, that's different. But if it's the actual filing of the application, nobody can charge for it. So if you go down to your local VSO's office and file the application for this benefit, they can't charge you for it. And not that the VSO would anyway, but just so you're aware that if you go to someone else and they say, I'm going to file this application for you, but it's going to be $5,000 or, whatever somebody would say. Well, that is not, they can't do that. If they're VA accredited, they cannot charge for it. For the application again. So it's just something to be aware of, and something to be cautious about. If somebody is trying to charge you for the actual application, you need to know that you don't have to pay for that. But if somebody is doing planning to help you get qualified for the VA, that's different. That's separate from that. That can be charged for, and the VA says that's the case. Just to give you an idea too of how this functions a little differently than Medicaid, I've mentioned a couple of things already. But with Medicaid, that amount that someone's allowed to have is very different from what the VA says someone's allowed to have, or how they get to that number is very different. So for a single person on trying to receive Medicaid, they are only allowed to have roughly $2,000 in assets. They place a lien on the home as care is provided. They can have a car, one vehicle that's exempt, and then roughly $1,500 in life insurance face value. Anything over that, if there's a cash value, they count as a countable asset. So that's a single person for Medicaid, which means that's a lot lower than what somebody could have with the VA, right? That's not the same calculation then of which one somebody would qualify for. If you're talking about 130 that somebody's allowed to keep versus 2,000, that's a big difference. And like I said, even for a single person on the VA, the home is exempt. The VA does not place like a lien on the home for that. For married couples, though, this is where Medicaid is a little closer to the VA's rules on this. The home for the healthy spouse, if one spouse is living at home still, is completely exempt. The retirement accounts of the healthy spouse are exempt. So like IRAs, 401ks, those are exempt. The same sort of rules around the car, the one vehicle is exempt. The $1,500 in life insurance is exempt. And then a prepaid funeral policy of around $15,000 or so that's irrevocably assigned to the funeral, that it can be exempt as well. But then all of the other assets that that married couple has, whether it's the spouse who's receiving care, their retirement accounts, or individual or joint just checking accounts, cash accounts in general, other pieces of real estate, they pool that again in value. They don't liquidate things. They just take the value of everything and say, all right, here's the available assets that you have. They then divide that in half and say, we won't force someone to keep less than $50,000 if the half, that divided in half number, is less than 50. They can't force them below that, but they also can't keep more than 130,000 roughly. So that's where they're closer to the VA. So if a married couple has $500,000 in available assets, they are not going to keep 250. They have to spend down to that 130 still. But it varies a little bit from the VA the VA's calculations on that. And they tried to use similar rules when the VA changed the rules to that. They tried to mirror Medicaid, but of course they did it just different enough where you still have to be aware that there is a difference. And like I said, with Medicaid, there's no amount of gifting you can do, regardless of whether you're already potentially qualified or not, without it potentially being a problem for Medicaid. They don't do that same definition of, well, you were already qualified, so that doesn't count as a divestment. Now, if you gave something away in the 5 years before your care, it still does potentially count against that person. So they're different. I'm talking about Medicaid, even though the topic today is on the VA, just because they often are used somewhat simultaneously, or sort of the VA can be a way to bridge the gap for somebody to Medicaid, but it's they also have somewhat similar rules that people often get confused. For both the VA and Medicaid, though, there's no amount of like dollar amount you're allowed to gift per year and have it be okay. In terms of this gets brought up a lot. Of people ask, well, isn't there $15,000 that you can give to everybody and that's okay? Not for Medicaid or the VA. That is a gift tax exclusion. So what that means is if you only gave $10,000 to your brother or your sister, well, you don't have to file a gift tax return because you were within the currently $15,000. But if you go over that, all that means is you file a gift tax return and it lowers your end of life exemption, which is 11.7 million federally today. But that is the rules for the IRS. That is not the rules for Medicaid or the VA. The VA, like I said, a divestment only occurs if it helped you get qualified. But if you still thought that gift tax exclusion would help you get around a divestment, it won't. The VA and Medicaid, for that purpose, say no amount of gifting is okay. It does not help. There's no amount that you can gift sort of as a safe harbor. So just be very aware that if you're doing that strategy, thinking you're gonna get around those qualifications, you have to be very careful. And any advice that somebody would tell you to do that is potentially dangerous as well. So with the VA, like I mentioned before, it is incredibly important that you make sure when you're talking to an attorney about this type of planning that you do it with somebody who is accredited through the VA. You can actually search your local or search the VA's website for VA accredited attorneys. So you can kind of cross-reference that and see, okay, is this person actually accredited with the VA, or are they just saying they are, right? I mean, I don't know who would just say that they are, because that would be really not okay for them to do that. But just be aware that you have a resource to look this up too. Some VA accredited attorneys specialize in different things. For example, some are more focused on helping veterans whose benefits have been denied for some reason to kind of dispute that denial and say, well, this shouldn't have been denied. Whereas some VA accredited attorneys are more like what we do, where we're using it from a perspective of long-term care planning potentially. So just because someone's VA accredited doesn't mean they all do the same thing either. So just be aware of that. So that's why I say cross-reference it with sort of when you're looking at a certain attorney to talk to. Like I said, all of us here are VA accredited, so you can come in and talk to any of us about these benefits and planning around them, and we could be able to give you advice on your situation. I'm not seeing any questions, so I'll just give you one last reminder that there will be a couple of materials given out to you. One is the actual flyer with those specific VA dollar amounts on there for those pension benefit. It'll tell you the exact dollar amounts that are escaping my mind right now. But then you'll also receive that feedback form, which will give you a place to come in and or mark down that you want to come in and talk to one of us, and we reach out then and set up a time to talk. And again, that is complimentary. It doesn't cost you anything to come talk to us. And then one final reminder that if you do want to attend our public seminar next Wednesday at the Bordini Center in Appleton, just be sure to sign up in advance on Estate Planning Live, just estateplanning.com, so that you can sign up for that. Just because, again, space is limited and it's important to get in while you can. It's not guaranteed that if someone stops in the day of without signing up in advance, that there's going to be any spots available. We're just limited with what the facility is allowing us to have right now. So with that, I will let you guys go enjoy the rest of your day, and I look forward to seeing anybody in person